PK Misra sir. Namaskar sir. Vice Chancellor Jharkhand University of Technology. I am welcoming our Honorable Director sir, Sri B.S. Ramachandran sir. Namaskar sir.
Thank you.
To be as a guest of honor of today's program. I am welcoming Sri Amyo Kalidaha, Senior Scientific Officer, Department of Science and Technology, Government of West Bengal. And I am welcoming all our online viewers of this program through our Facebook pages and online pages. As you know that due to this corona pandemics, our centers are closed, but still we are on the running the online programs for the visitors. Various programs our centers are organizing. And today, in continuation of that, we are organizing the intellectual property rights this webinar. So just I take opportunity to introduce our chief guest, sir. Professor Pradeep Kumar Misra is presently working as a Vice Chancellor of Jharkhand University of Technology. He was a Professor of Chemical Engineering, IIT BHU Banarasi, and sir has published more than 100 papers in the reputed journals, and sir have more than 5 patents also in his own. And he authored and edited more than 12 books, contributed so many chapters in the books and encyclopedia. And he also successfully completed a sponsored research project consultancy worth more than 20 crores. He got the funding from the Department of Science and Technology, Technical Education of Uttar Pradesh, and so various places. Professor P.K. Misra is actively contributing to the area of bioenergy and wastewater treatment. He was appointed as a chairman to the Committee for Formulation of Disposal of Standard to Textile Industry. He has also a member of 2 other important committee formulated charters of distilleries and sugar industries, and he engaged with the Central Pollution Control Board, Central for the Monitoring and Majority of Ganga Basin for the last 3 years. Sir has awarded various awards. Sir got Dr. B.G. Patel Memorial Award in 2020 for entrepreneurship trainers and educators, mentor, and Dr. Sireen Gandhiya Memorial Sustainability Award in 2017. Sir is previously working in Malviya as a director of Malviya Center of Innovation and Incubation, IIT BHU, and sir has a lot of contribution. And now he is contributing in the rural area of Jharkhand and Uttar Pradesh and Bihar also. So thank you, sir, for giving me the time for our center. And I am just introducing our honorable director, sir. Our honorable director, sir, Sri B.S. Ramachandran, sir, is working as a director, Birla Industrial Technological Museum, which is the oldest museum in India, formulated in 1959. And now Dr. Sasinath Mandal has joined. And sir, I welcome you also, sir, in this program. So Dr. Ramachandran sir has already worked more than 20 years in Calicut Science Center. There he worked in lot in area in astronomy area. He worked, and at present sir is engaged with various project in Birla Museum, as well as our 5 satellite center is under the leadership of sir, is grooming well. And under the leadership of sir, the center innovation hub Digha Science Center inaugurated, Barghar Science Center inaugurated, and various traveling exhibitions as well as the permanent exhibition has been developed under the leadership of our director, sir. And he is the inspiring personality for all our activity in the center, and thank you for sir giving such kind of independency for doing the work for all the centers of our Birla Industrial Technological Museum. Sri Amyo Kumar Kalidaha is the senior. I am just taking opportunity to introduce our one of the guests, Mr. Amyo Kumar Kalidaha. Mr. Kalidaha has completed his master's from IIT Kharagpur, West Bengal. He is at present senior scientific officer in Department of Science and Technology, Government of West Bengal. He is the district science advisor in 24th Chaubis Paragna, as well as in Bardhaman district also, Purva Bardhaman and Paschim Bardhaman. He has been awarded gold medal award for chemistry, Bardhaman Sammelini gold medal for securing the highest marks in MSc chemistry. And he has so many publications and various. He is very much known for the communicating science in the rural areas through Department of Science and Technology. I am taking opportunity to welcome Dr. Sasinath Mandal, sir. He is one of the today's chief speaker. Dr. Sasinath Mandal is worked as a deputy director of public instruction, Government of West Bengal, Department of Higher Education, and presently he is working as an associate professor at Hooghly Mohsin College. Sir has published more than 50 research papers, more than books, and he has a lot of communicating skill of this patent and all in vernacular language, Hindi, Bangla, as well as in Maithili also. He's very good known to Maithili also. And so sir has edited so many books, and I'm welcoming all of our guests in this program. And I am now inviting our director, sir, to give his valuable speech for this program, sir.
Hello, good afternoon to one and all. Honorable Vice Chancellor, distinguished speakers, I'm very happy to know that Honorable Vice Chancellor is having 5 patents. So we have got the right person for the right job. I'm very sure that with his broad knowledge, the people who are watching this webinar will be highly utilized. So I don't want to take much time because the dash should be given to the Vice Chancellor. Yeah. I'll speak a few sentences about IPR. The million-long years of human history, from the days of beast man to the modern man, could be mapped over a long flight of steps, each ascending step representing a major invention, introducing progressive change in lifestyle. The ability of human intellect in innovating a wide array of subjects like symbols, images, designs, languages, literary and artistic works, devices, technologies, improved plants and animals, etc., all having utility to the community is called intellectual property. When this property, like any other movable or immovable property, is governed by law for conferring ownership on the holder. Ownership is very important. IPR is very, very important in the present day context. The resulting legal right on the intellectual property is called intellectual property right. Intellectual property is recognized as a powerful tool for economic growth and represented as a symbol of nation's wealth and competitiveness. Intellectual property is the creation of human mind. According to World Intellectual Property Organization, WIPO, these creations include inventions, literary and artistic works, symbols, names, images, and designs used in commerce. Intellectual property are considered as assets and safeguarded and commercialized through legal rights given to the IP creators, which are known as IPR. As per the TRIPS agreement, geographical indications, layout, design, IPR, patents, trademarks, copyrights, everything is there coming under IPR. The government of India has given due importance to IPR, and it is promoting and doing a lot of activities related to IPR. And I'm very sure that this webinar and there is a lot of important things related to the students. We have to reach the students and researchers. That's very, very important. However, there is still an immense need to creating massive awareness on IPR rights for school students to generate an IP perception and to inculcate an IP literacy. IP literacy is very, very important. The online webinar like this is expected to create wide awareness among the researchers, students, and scientific fraternity and academia. I wish all the success to the webinar on IPR. I'm very happy that Digha Science Center has chosen a nice topic, and I wish them all the very best. I'm very sure that this 2-day seminar will be very fruitful for the people who are watching this webinar. Thank you. Thanks a lot.
Thank you very much, sir, for your encouraging words. And now I am inviting our chief guest, our honorable Vice Chancellor, Professor P.K. Misra, sir, who is the inspiring force for thousands of students for developing so many startups. And sir has, I think, more than 30 startups has been started under the leadership of sir in the Malviya Center of Innovation and Incubation. So sir, now we want to enlighten with your all good leadership words, sir.
Thank you very much. Thank you very much, Dr. Ranjan, and Honorable Director Sri Ramachandran ji, the honorable colleagues today present in this particular seminar, Amaya Kumar sir, Dr. Sasinath Mandal. I'm indebted to you people that you have invited me today for giving my viewpoint. I'm not expert on IPR. I might have filed the patent, so that had been held by attorneys, patent attorneys. But yes, I do understand how it can be done. And I hope there are good number of experts who will be educating, young minds to enter into this arena to understand the importance of intellectual property and how they can be part of that. So thank you once again. Let us understand how it is essential and why it is required. So whenever I talk somewhere, I talk about the Panchshila of New Millennium. And this Panchshila of New Millennium says, if India wants to become one of the most developed nation, he has to adhere to the rule of Panchshila of New Millennium given by Professor R.A. Maselkar. And I hope everybody knows him, Professor R.A. Maselkar, in this gathering. Everybody knows. So in Pune Science Congress in 2001, he has given this Panchshila. And what was this Panchshila? Student-centric education, woman-centric family, human-centric development, knowledge-centric society, and innovation-centered India. So last two you just take care of. Now you go through 3, student-centric education. You give such kind of education where a student can become innovative, can learn the trick so that they can experiment. So that was one point. Second, knowledge-centered society means society has to give proper importance to the knowledge creation, and then only this country can become one of the most developed nation. And finally, that he says that India should be innovation-centric. What is innovation? Innovation is nothing but invention into commercialization. That is the definition I love. Any invention which can be commercialized is a kind of innovation. So if commercialization is involved there, it means that you want to take advantage of that particular product in terms of money. So then only, you protect your right to get the required amount of money you have invested into your product in terms of knowledge, in terms of development. There comes this intellectual property right, because you have created certain thing, so you need benefit of that, out of that. But there is some ethical question sometimes. If somebody says whether IPR is very much ethical or not, in certain cases we have seen, even today in this pandemic situation, when there was COVID, we were talking why this vaccine company have patented their product. If they can be patent free, every one of citizen of this planet can get a benefit of all kind of vaccine. So there is an ethical question also, but majority of industrial product, we need certain kind of property rights or legal rights, because I have developed that, I have invested my education, I have invested my knowledge, I have invested everything. So I should certainly be given economic advantage of that. So that is the basic thing why intellectual property right is very much required. So if you go back and try to learn what were the earlier examples, the first example which lies in the groups of most valuable patents is of telephone. When the improvement in telegraphy happened long back in March 7, 1876, and the patent number was US 174465, and inventors were Alexander Graham Bell and Thomas Watson, and this was the patent. It is being considered one of the most valuable patent in the history. So that has given a lot of money, lot of name and fame to the inventors. So I'll be discussing 2, 3. The second one was the two-cone drill bit. The person who started this patent number US 930758, it was granted in August 10, 1909, nearly 200 years back. So Harvard R. Hughes has get this patent, this particular product patented. So right from the simple drill bit, we have gone to the oil well drilling. So this kind of changes could take place when somebody has created some knowledge and he was given the legal right to get monetary benefit out of that, and later on, after some time when patent is open to everybody, others can come in, pitch in, and do the required improvement in the products. So similarly, the search engines, the Google was the first to create that, and he has reaped a lot of profit out of that. And now there are other, search engines are there in the world, and they are also coming and improving upon the art. The safety razor, very small, very simple thing, which is being used every day for clear our faces to make ourselves presentable. That was patented in long back, November 15, 1904, by inventor King Gillette, and that is why the company still, which is manufacturing the razors, the leading company is Gillette. So simplest one was the paper clip. Everybody knows how simple it is, just turning wire into a particular shape and getting the patent out of that. So those ideas which can solve the problems of the society can be patented, and if they are having commercial value, certainly the advantage should be given to the person who is doing the job. So what exactly the intellectual property right? I will not take much of the time, but yes, 10 to 15 minutes, I will be talking about on this intellectual property right, and then this conference will be open to listen all the experts who are working in the area. The term intellectual property is related to the human brain applied for creativity and invention. So whenever we do certain kind of creative work or do certain kind of invention, that can be covered under this intellectual property. So various efforts in terms of the manpower, energy, skill, money are required to invent or create something new. Whenever some idea come into my mind, I start working. I try to gather different kind of knowledge. I try to evaluate that idea based upon the knowledge I am having, based upon the knowledge available in open domain. Then I try to create that idea into the product. Then I try to test the product into the market. So all these activities needs a lot of energy, lots of investment, and a lot of knowledge sharing. So certainly this is a kind of property to a particular person. So the ultimate idea by which invention or creation took place is an intangible property of the person who took pains for the invention or the creation of the same. Therefore, as per the law, legal rights are monopoly rights. Because this IPR is not simply legal right, it's a kind of monopoly right for a certain period. 10 years, 15 years, 20 years, that depends upon nation to nation. Okay, so it's given to the creator, innovator, so that he can harvest economic benefit out of that. Otherwise, his all effort can be stolen by somebody else. If somebody else duplicate the idea instantly, he can get the benefit out of that. So these IPR can be classified into different categories like patent, trademark, industrial design, layout design of semiconductor integrated circuit, geographic indication of sources, copyright and related rights. It has already been known to everybody. But patent is one of the most important. If I talk about the science and technology or medicine, this kind of activity. So I'll be concentrating with a majority of my talk to the patent. So patent is nothing but an intellectual property right granted to inventor by concerned government office for his novel technical invention. The term invention means solution of any problem. If you are having any problem in the society that needs certain kind of invention or innovation, whatever you say. So if I am going to develop a product to solve the certain problem in the society, I should certainly like to have certain kind of reward. So that reward can be in terms of money or can be in terms of recognition. So among the different types of IPR, patents are considered the most valuable and rightly so, because they are majority of time solving the societal problem with scientific bent of mind. So now, if I'm interested to do the patent, the first thing is required to understand what are the criteria for patentability, whether my idea can be patented or not. So that is the first step. So the patentability of any invention needs to fulfill following criteria. Whether the idea I'm having is useful to the society or not. First step. If the idea is useful, means invention must have industrial applicability or applied for practical purposes. Means if there is a problem, there is a solution. Second one, whether my idea is novelty or not. Because when I'm thinking something, there may be other persons who are thinking in the same direction. But if I'm having novelty in my idea, means invention must be new technology which has not been published or available in prior art of the country or elsewhere in the world before the data patent filing. So, our prior art, we have to take care whether there is anything similar to or not. So that is why we go for extensive patent search to understand whether there are similar things already there in the market or there in the lab or there somewhere published or not. And third one is non-obviousness. That is also very important. So invention which can be done by any ordinary skilled person is obvious and cannot be patentable. Means the minor modification into the existing things that is being done by any skilled or semi-skilled person is certainly not a patentable idea. In addition to that, there are few things which is always not non-patentable. So what are this? So as per the Section 3 of the Patent Act, 1970, the following are not patentable. That is frivolous invention, invention against the natural law. If somebody comes out that, I can create a perpetual machine. So it is not scientific, so it is not patentable. Invention which are not fair to the health of human, animal, plant, life, environment, as well as the contrary to the public order of morality. So ethics, morality, health, environment, all these are, criterion before getting the patent. Or discovery of any living thing, substances or chemical obtained by merely mixing two things. These cannot be patented. So in addition to that, invention related to the atomic energy and related to the security of the country is also not a patentable idea. So a person who is approaching for patent should certainly have this kind of basic knowledge. So if I'm interested to file the patent, there are 4 patent offices. Everybody knows Chennai, Mumbai, Delhi, and Kolkata. The applicant had to file a patent application in appropriate form with all the relevant information concerned with the invention, such as description, claim, drawing, abstract. I mean the detail, which will make others to decide about the novelty of your product, and then you can go for provisional specification to establish the priority of the invention. And thereafter, within a 12 months, applicant had to file complete specification. Sometimes what is happening that I'm working on certain product, but I'm having some kind of fear that somebody else can file patent before me. So people go for prior art and submit that, but that is the condition that complete filing of the patent should take within a year or so. Then you go for publication or application. Then you should be open for any kind of opposition to the patent. Because if you are filing the patent, there will be a number of people who will be working in the similar area. So somebody can come and file the opposition to the patent that I am working in this area, so your patent should not be granted. So we should also, then you could go for request for examination, whether their claim is right or not. And if during the examination certain questions come, you have to clarify that. If objection is raised based upon your knowledge, based upon your work, based upon your data, based upon your experiment, you have to come out for the clarification. And then finally, patent is granted and by the controller after overcoming the objection raised by the examination. And there is as per the Patent Amendment Act 2002, the applicant has to pay renewal fee time to time to keep patent in force. And generally, this patent is being granted for patentee for around 20 years, so that after expiry of the patent, others can enter into the domain and can create further innovation, can create further improvement, and so that you cannot stop the science to grow. That is why for limited period, this patent is being granted. And the temporary monopoly is awarded. That is why temporary monopoly is not that you have been awarded monopoly for lifelong. It's not that. So, in science and technology is giving benefit to the inventor through the limited monopoly or temporary monopoly. So, the temporary monopoly allows the inventor to seek monetary benefits from their invention for a specific period of time while preventing the rapid duplication of invention that could potentially cut into an inventor's profit or return, and also decrease their incentive to invent or even improvise upon their invention. So this is the reason and why this temporary IPR granted for science and technology invention, that is also is to be understood. So when a permanent IPR is granted, there is a threat that prevents the further development or improvement of the innovation. Nobody will enter, nobody will try to understand the science behind that. And that is why the limited period is the right kind of monopoly given to that. So it can also raise the cost of newer technology. If somebody has been given monopoly for entire life period, so newer product he has to develop. Nobody can enter into that. So that also hamper the science, hamper the development, and hamper the economic activity of the country. So this is especially true if the new technologies can enhance the productivity, especially when used in the economic activities. For the economic progress is restricted if the original invention is permanently protected. This restriction may prove to be hindrance to the development of the economy of the country. So there is a conflict at the heart of IPR in the field of science and technology. And I already told you there is the ethical conflict, there is economic conflict, there is developmental conflict. So those has to be addressed time to time based upon what kind of situation the country is facing. So I should not keep on talking. There are experts. They will be talking a lot about IPR, how this can be done, what is the science behind that. I hope I have given the basic glimpses. So thank you very much for inviting me to share whatever little knowledge I am having pertaining to the patenting and IPR. Thank you very much. Thanks a lot.
Thank you very much, sir, for giving the very knowledgeable information and speech, sir. The NCSM has a lot of, in all the regional center, district centers and national center, we have an innovation center, sir, innovation hubs. And this innovation hub is promoting the innovation type of culture among the school students, sir. I hope your speech will help to file more and more patent from our side also through Innovation Hub, and your support will continue. We will get your support. Your support, sir. And my director, sir, is also there. I think he will also take all type of things to promoting patent, and the people like you can help us a lot for our solving the problem, sir. Thank you very much, sir.
I'm always there for any kind of services, any kind of association, and I also, just welcome your moves and decisions, Ramchandranji and yourself, Niranjanji. Thank you very much.
Thank you, sir. Thank you.
Sir, your speech was very crisp and excellent. I really enjoyed it. Actually.
Thank you, sir. Thanks a lot. You have initiated the talk, sir. You have given the base background. I have built upon that.
Oh, thank you, sir. You have done a fantastic job. Thank you.
Thank you, sir. Thank you. So now I am inviting Sri Amiyo Kumar Kalidaha for giving his short inaugural some speech, because tomorrow his more session is there. Today, Dr. Sasinath Mandal will take the leading for the program main session of the speaking. So please, Sri, I'm inviting Mr. Sri Amiyo Kalidaha to give his short speech for this program.
Thank you, Niranjan, and respected Professor P.K. Mishra, Vice Chancellor, Jharkhand University of Technology, then Mr. V.S. Ramachandran, Director, BITM, Dr. Shoshinath Mondal, Associate Professor, Hooghly Mohsin College, Government of West Bengal, and Mr. Niranjan Gupta, my very own friend, Project Coordinator, Digha Science Center under NCSM, Government of India. The initiative of such type of program by Digha Science Center in a particular and NCSM in a general is a really nice step towards the modern economy. As Professor Mishra told, is rightly actually Professor Mishra and Mr. Ramachandran, both of them narrated almost every parts of the IP. We can say every parts means every parts, really speaking. So from today and tomorrow, there will be a lot of discussions. In fact, it is very true, as Professor Mishra told, considering the present COVID situation in particular, when people from not only from India or from third world country, even the developing country, developed country like US and other countries also, they are claiming that please, COVID vaccine should be free from patent. Okay, but as he also mentioned, it is an incentive for the innovator. It is an incentive for the scientist community to work further. Obviously, we are bound to help the society. We are bound to help the mankind. It is okay, no problem is that. But anyway, economic benefit always motivates each and every individual in the earth, no doubt about it. So starting from a very small items, means day-to-day use, this brush, teeth brush, to the modern high economy rocket, everything comes under the patent regime. And not only the patent regime, besides this, there are a lot of other things which we come across each and every day in our daily life, which falls under different forms of the IPs. I'm not elaborating anything in detail because we are lagging in time. So I am stopping over here. Only thing I want to mention that we at Department of Science and Technology and Biotechnology, Government of West Bengal, we are associated with NCSM. Our director sir is occasionally visit our department, and we do conduct a lot of programs in different science center, regional science centers with our limited funding or something. And one thing to mention over here that at our department, we are having one council, West Bengal State Council of Science and Technology, and there we are having PIC, Patent Information Center. So we are having full-fledged patent agent over there, qualified patent agents are there. So anyone who is interested to do some novelty check, searching, then doing patent or trademark registration, that can be done at our department. And we usually help the many students, many faculties in our state in this respect. And not only the faculties and students, we are helping the grassroots innovator. You know, there are a lot of grassroots innovators are there who may not have that much educational qualification, but still they are developing a lot of innovative things which may be useful to the society in general. So whoever is attending this conference or this program through online mode, I particularly welcome on behalf of my department as my council that you are most welcome to visit our department just to check your novelty work. And if you feel if your work is really useful, then you can come and work with our department, and we'll surely help you to get your work patented. Thank you very much. Wish a best success of this 2 days e-workshop on IPR. I wish a grand success to NCSM and all the regional science center under NCSM and BITM. All the best. Thank you very much.
Thank you very much, Mr. Kalidaha, for your valuable speech, and we will certainly take all opportunity to get your department support. And thank you very much for this. I'm happy to inform you that the program, in this program, more than 161 registration has been done from various states of the India. And this program broadcasted live through our Facebook network of National Council of Science Museum, as well as Digha Science Center, also, and Ministry of Culture, Government of India also. Thank you very much, Mr. Kalidaha. And now I am inviting Dr. Sasinath Mandal, who is the main speaker for the today's program. Dr. Sasinath Mandal. Hello, sir. Hello. Hello. Mandal,
yes, sir. I'm here, sir. I'm there.
Okay. So, Dr. Sasinath Mandal, sir, and Dr. Sasinath, I already introduced earlier also that Dr. Mandal was the DDPI of the Department of Higher Education. And if I say him as a social innovator, it is also not wrong, because he is always involved in various new ideas in the society also, and that's why I called him as a social innovator also in some time in our area. And he supported a lot of students, and presently he is the chairman also of Durgapur that law college also, and he has worked in various positions in the government of West Bengal, Department of Education. So now I just inviting him to deliver his valuable speech and for developing the patent culture in the India. Thank you, sir. Now,
thank you, Dr. Niranjan Gupta ji.
sir.
Before I start, the August guest present here, Professor Ramachandran, Director of NCSM, Professor Dr. P.K. Mishra, the Vice Chancellor, sir, my Dada, Dr. Omyu Kumar Kalidaho, and all the audience who are watching this wonderful seminar on electronic media, on social media. My friend Dr. Niranjan Gupta ji. Today's topic is a really wonderful one. As Director Sir and Professor Mishra, Professor Kalidaha already stated about the importance of IPR in today's society. That's why I try to focus on the overall idea of IP, focusing the concept of creative works and IP protection. We all know that intellectual properties concept is not new to us. In fact, this intellectual property has created a world of renaissance. It is not India or this area of the world where we started this, but it is a global concept. And if you take the example, why the importance of this IP law increased, then we get only one word, that is called the industrial use. From industrial perspective only, from 1709 and 10, one initiative of Britain by the Statute of N, where for the first time they thought of giving a protection to IP innovative works, creative works. So from 1710 to this 2021, we have improved a lot. And that improvement is only due to the relevance and the importance of this IP in industry. And so far, NCSM and the Digha Science Center is concerned, this is not the new one. They have always taken initiatives to invite people, students of this IPR, students of this IP law, to interact, to discuss these pertinent issues. So in this time also, NCSM and DSC Digha has really took the initiative once again to discuss. So taking the reference of entire world, the importance of this IP in this age of IP, let me start with one example. If any new invention and innovation has come to this world, then always take some kind of investment. And that investment may be of investment of money, investment of labor, investment of infrastructure. So until these investments are rewarded properly, the respect to that particular innovation will not be possible. And taking this point only, the development of IPR and IP law has got a new dimension. So this intellectual property or right or intellectual property law is not a new phenomenon, but it is an evergreening subject. It is an evergreen areas for the researcher, for the creator. So this IP rights or IP law connects every aspects of life. May it be science and technology, may it be agriculture, may it be creative works like artistic work, literary work, may it be development in the field of agriculture. Everywhere we are in any way connecting ourselves with IP. Therefore, if this is so important, then the most important aspect comes with all of us, that what is the position of its protection. So we are aware of the situation that when one development is made, one improvement is made, one innovation is made, the challenge is always come with the protection. So what are the protective measures that has been given in our law? That we'll discuss. But the example what I am talking about, if someone has created, suppose if A has created a thing and the A is under a service of B, A is under a service of B and A has created something under the service of B, then who will own that creation, A or B? So this question is very alarming question for the researchers, for the creators. But this is not possible to reply till we understand what is all about the legal position. So I will discuss that way that we will get the answer of these kind of questions from today's lecture. So the first thing what we get is the oldest thing, that is the copyright. because we know the birth of this IP rights or law was copyright, which was later on converted into industrial property. Thereafter, we got a lot of things. We got patent, we got industrial design, we got geographical indications, we got farmers' rights, a lot of things we got. But then what is copyright? We all know that in very brief, copyright is creative work in terms of literature, in terms of cinematograph, in terms of music, in terms of nowadays digital creative works. So in all these areas, including this social media, if someone creates anything, that means he has a superior right on that creation. But if he has got the right, that means he has got the authority to use, to dispose, to sell, to transfer. But from where the rights are coming? So we all know that these rights these IP rights are known as the bundle of rights, because these IP rights constitute lot of rights called copyright, patent, trademark, design, lot of things are there. So these are the bundle of rights. So when someone creates anything in terms of literary work, cinematography work, musical works, digital work, these all required protection. So this protection means if we are getting right, so right has a certain definition in law. So right is the legally protected interest. So whenever we are getting right, that means we are getting legally protected interest. So that interest means we have the authority to knock the door of law to get the thing protected. And when we get the authority to knock the door of law or judiciary, that means we have got the right protected. That's why we have knocked the door. So getting this right is the purpose of IP law. So until IP law will come in operation, the exclusiveness of right is not possible. So to enjoy exclusiveness of right, law is very important. So whenever we create anything in terms of literary work, in terms of creative works, in terms of any musical works, we have to get the right on those works. And when we get the rights, that means we have get legally protected interest. And that is provided by our own law, Copyright Act 1957. Then we are coming to the patent. The patent is nothing but, again, like copyright is an exclusive right. So when we get exclusive right on patent, we get exclusive right on patent only upon getting that of our that of our creative works patented through the prescribed procedure of law. And once we get the patent through the law as established, we are getting the right, patent right. We'll become the patentee. So there's a slight difference between this copyright and patent here. When we are creating anything in copyright, we are getting the right because the registration is not mandatory in case of copyright. But in case of patent, until we get the patent, we cannot claim that this is our creation. There's an ample opportunity of infringement. And to get the authority, to get the legally protected interest, the patent has to be registered. And the registration is a process. Registration, the process through which every applicant who has got patent has to go through. And that process is nowadays in India, after the amendment we got a little easy process when we are applying the patent. Professor Misra has already discussed about the patent, how we are getting and what are the importance of the patent. We should focus on the rights, what we are getting, what we are enjoying. But that right is not possible till we are getting our patent registered in the prescribed mechanism. The process, I'm not going to the patent process because a lot of opportunities, in a lot of areas we have discussed that particular areas. Today I'm just going to discuss about the provisions, how we are getting protected those rights after getting patent. So after getting a right created, after following all the formalities, if once we get the right, the patent registered in the patent office, we are getting the right to be the patentee one. Therefore, we have got the exclusive right to enjoy the patent. And if any person, anybody, any third person disturb, interfere the absolute enjoyment of the patent, we have got the right to get it enforced through law. And in legal term, that is called, if any infringement is there, then we have got the right to get legal steps and to get the right enforced. And this enforcement requires certain legal procedures that we will discuss together. So the patent is an exclusive right after getting it registered, and that right is a right which we can enjoy exclusively. Next, I'm coming to trademark. Again, like this copyright and patent, we have another right, trademark. And this trademark is also an exclusive right where we can exclusive authority to use a particular trademark that is registered. And if we are getting any trademark registered to the authority, then we can use that of trademark as our own service, or that may be the product. There may be service mark, there may be trademark. So both the things need to be registered, and after the registration we can use those particular trademark. That may be a symbol, that may be that may be a photo, that may be a word, that may be a letter, that may be a combination of all also. So once we get registered, that also a right for all of us. And if any of us get those right registered, then we have got authority again to use it exclusively, and any infringement of that particular right also invites legal procedures. And again, that will be an infringement of trademark, and we'll get the authority to move to the appropriate forum, appropriate court of law to get our trademark protected. So this is another way of getting IP protected through judicial intervention. And these three rights are in regular use for industrial purposes. And besides this, there are other IP laws, IP rights, which are also protected by IP laws. So another important is geographical indications. Geographical indications is that kind of right where the right is always depending upon the geographical positions of certain areas, which is not naturally possible to get in other areas. It always varies from atmospheric conditioning. That may be temperature, that may be rainfall, that may be other reasons, and that may be soil, the availability of elements in soil. So taking all these things, when we are getting any spatial or any particular product, then we can claim geographical indications or GI for that particular product. The known disputes, known cases on these issues in entire world is aware of. We have lost lot of things on the ground of this GI due to delayed understanding of legal protection in India. We have lost a lot of markets of this basmati rice, Darjeeling tea, neem trees, a lot of things we lost. Though there were a lot of legal wars where we won the case, but we lost the market on those periods, the market of entire world. Because if we get GI first primarily, then we are getting larger market than other. Again, I'm citing one example here, how we lost the market of basmati. Simply, we know that basmati is our own product which cultivates in particular area, particular geographical conditions. But one company of US taking the studies on the particular areas of India, the atmosphere on which these particular rice cultivates, and they artificially tried cultivating these in areas of Texas, and finally after successful complication of that invention and innovations, they produce almost similar rice and they got the market naming that rice as Texmat. So this is one example, but there are a lot of areas where we lost, but finally we have got legal control on these areas and we are getting those things back in our favor on a long legal war. So protections are a very recent war in West Bengal and between West Bengal and Odisha about on the issues of Rasgulla. Is it Kolkata Rasgulla or is it Puri Rasgulla? So in that also, geographical indications are simple depending on the geographical conditioning. So when the thing is totally different, finally we got that Kolkata Rasgulla is made of something different and Puri Rasgulla is made of something different. Process is completely different. So that war was not at all expected, but anyhow it happened, and finally the government of West Bengal has got that GI. And areas in I am from Bardhaman. In Bardhaman also we have patent on this Mihidan and Sitabhog on certain. So these are the areas where those particular things are cultivated, are produced, both things, and GI can be obtained on those particular conditions. And if someone get this, again that person will get the market. So this is about also the commercial use or the industrial applications of that. Besides there are geographic conditions, beside there is a farmer's right. We know that though we have a lot of laws to protect this, we have a lot of judicial decisions also to protect these things. But still, whether farmers are getting their right protected, this is really a challenge. The law has come, but lot of confusion came with the law also. There are some rights which are restricted to farmers, but at the same time, some laws are there which has come to protect the interest of pharmaceutical, and these are also a separate protections. The knowledge, we are conscious. We are conscious about the right called copyright, right called patent, right called geographic indications, right called farmers' rights. But whether these all rights are available as per the law granted it to the people, these rights are really enforceable on the part who are really the owner, whether they are aware of these rights. So these are the challenges which still we are facing. In India, till date, the question of patent, the question of copyright, the question of industrial design, the question of trademark are restricted to a particular classes of people who are aware of these rights. But many areas are there where people have the rights, but they are not aware of these rights. Therefore, they are not getting these rights protected through the mechanism of law. So that is the work of, that is the task of the people like law students like us. And really what NCSM is doing is a wonderful piece of work where people are getting aware of these rights. So the protective mechanism, I'm not going to details on all these things because it requires a lot of times. I'm coming to the protective mechanisms. Copyright, patent, geographical indications, trademark are the areas where the infringement cases are larger. So what are the protections? If someone's copyright or patent or trademarks are infringed, now where one should go? So for that, in India, we have two-dimensional protection is available. We have two-dimensional protection is available in India. Firstly, we get the protection under the law from where we are getting the rights. Firstly, we are getting the law rights under the law from where we are getting the protection. Say, for example, for copyright. Once we get our copyright protected, may it be registered or unregistered. In case of unregistered copyright, we need to protect it through another kind of proof. If we have got our copyright registered, then it will be very easier for all of us to get it proved. But if it is not unregistered, then we need to prove this, that this is our work. If we are able to prove that is our work and it is being infringed, then we have two-dimensional protection. One is under the Copyright Act itself, another is again under Indian Penal Code. If our right is protected, may it be literary work, there may be musical work, may it be cinematography work, may it be adaptation work, may it be transformation work, may it be performance work. Everywhere we have the copyright. And if anyone infringes copyrights of any persons, he has got the right to move to the court of law for the infringement of those copyrights. And in the court of law, again, there are three kinds of protection available. One is the protection may be available through civil orders, where the compensation may be awarded. Consider the amount of losses. Second is the criminal protection is also available. In someone, this is available mostly in case of piracy work, pirated work. We know that in India, in Indian law, the computer-related works or softwares are also protected under copyright. It is considered a literary work. So in case of protection of any violations of any computer software or any cinematography acts or cinematography works, the protection is required. And this is available through piracy. And in case of any pirated work, in case of any loss of through pirated works, one can take actions through criminal courts also. In that case, the person, the pirater who has pirated the works, will have to go behind the bar, and there may be punishment up to 3 years infringement in case of any piracy work. So under IPC, they can get the protection. They can bring those pirated before the law, before the court, under the Indian Penal Code, as well as under Copyright Act. And another kind of protection is there, which is though English system, but that is also applied in India, that is administrative protection. In case of any prior information of any piracy or pirated works is being going on, then one can take also this administrative help, administrative protections, where the owner or the author of the work can take the help of administrations, and there can be a raid on the place where the piracy is going on, and there may be seizure, there may be there may be imposition of fine and seizure of the products which are being used for the piracy, and the pirated products may be seized by the administrative authority. So in this way we can get our copyright infringement protected. In case of patent also, if someone's patent is being infringed, if someone's patent is being violated, then also he has got twofold rights. One is under patent law, where a person can move the respective the person authority within the jurisdictions where the particular incidents or infringement has happened, and take the help of the local authority and take the help of the local police, and can demand the interventions and take the recourse of law, and there can be criminal proceedings against the protector. And if any damages, if any laws happen to the owner or the patentee, then he has another right to get those losses realized from the infringer through availing the civil remedies provisions. These are also available in patent. Similarly, in case of trademark also, if someone's trademark is infringed or violated, then that person has the authority, again the right, to get those rights reinforced or protected by taking two-dimensional measures, again under Trademark Act or under Indian Penal Code. One can take the advantage. And similarly, they can get the criminal order, and like when patent also, one can get the order of infringement. One can get the order of infringement up to 3 years for the violations of patent law. And there is a fine also. Up to 5 lakhs fine may be imposed for the violations. And before this fine, they can realize actual loss suffered by a person or actual gain realized by the person by using his or her patent. That is also available. So these are legal protections available. But besides this, the one most important areas which is very alarming nowadays is the protection of these IP laws after arrival of these cyber law or cyber activities. That is the protection of IP rights on social media or on internet. That is nowadays very important issues. After the arrival of Information Technology Act 2000, we have got a law for the protection of our transactions through internet or electronic interventions. But the real law, real cyber we got in 2008 after the amendment of that IT law. And after this amendment, we have got lot of areas, lot of provisions for the protection of every activities violating intellectual property rights on internet. On internet, two kind of rights are almost violated. One is creative, that is the copyright related. A second is the computer related, the software related violations. This is very common. So the alarming thing I would like to mention here is what we are always using, like transferring or forwarding the photographs, messages directly after receiving the messages from one person to others. But through this wonderful platform of NCSM, I'd like to aware the people about the law. So the question, the platform, if you take the Facebook, if you take the WhatsApp, if you take Instagram, everywhere people are always working. People means the people who are involved themselves in these cybernetics. They are looking for these likes and comments. See, likes and comments are fine, but sharing has some problem. Sharing has some problem. So we should always remain conscious, always remain cautious before sharing anybody's creative work. If someone is inviting us to like and share, that means the person is giving us the offer. The offer. In terms of contractual law, that is the offer. It always depends on us to accept. And as per contract law, once offer is accepted, it becomes a promise, that means it becomes a contract. So whenever someone is inviting us to share or like, that means someone is inviting us to accept the offer. And it's up to us to accept it or not. But when we accept it, it becomes a promise. So it's a very alarming situation, very alarming areas where we have to remain cautious. And IT law is very clear about that. If any messages which involve any privacy issues, any pornography issues, any material issues which are important for the persons or creators, then before forwarding this, we have to remain cautious, because forwarding, spreading all these things are absolutely an offense. Now we know that law has 1,000 eyes. What we are watching, that is our perspective. But the lawyers and judges have their own perspectives, and that may not match with us. And that may invite other trouble for all of us. So these IP rights, intellectual property rights has given authority to a person to create. And if someone has created, that is his property. Because the copyright does not require compulsory registration. Creation is sufficient. Idea has no value. But expression of idea is created, is right under copyright. But when someone has created anything, any photograph, any picture, any image, any even message, good morning messages, if someone has created, that is his property. And when we are using this, forwarding this without his permission, in fact, we are violating law. But in strict sense, so how many of us are conscious? How many of us are aware? Most of us are not. So better to send good morning through writing good morning rather forwarding these photographs or these flowers, it will be wise to send a good morning no, by writing good morning only. It will always be safe, because someone has created that photograph, someone has created that flower, someone has created that messages, and we are taking advantage of that. We're using the messages for our purpose. I wish to someone good morning, and I'm taking the message from other person and sending it to other person. So I'm using his product without taking his permission. So that's a very critical perspective. Being a student of law, I'm making it very critical. It is not so critical, but it is also required, because hundreds of people are watching this. It is very important to understand the real perspective involved in these areas. So IP right is the legally protected interest, and IP law is the particular instrument which will protect the interest. So the combination of IT right and IT law together is a wonderful thing, and without taking this together, studying this together, there may be confusion to the students, to the viewers. So the IT law, information technology law, has prescribed very strict provisions of punishment. Again, here also, IT law is also not self-sufficient in terms of these proceedings. In case of cyber activities, in case of involvement of any IP activities on cyber world, also IT law as well as Indian Penal Code will come in operation. IT law has some provisions which deals with the activities of protecting IP rights on cyber areas, but this is not exhaustive one. Indian Penal Code will also come. Say, for example, I'm just stalking someone. It is also given under IT law, but also given under under this Indian Penal Code. Defamation. If someone has created one message and that may defame another person, and without knowing the basic objective of the person who has created that particular symbol or picture and forwarded it to me, I have forwarded it to some other person. That means I became the part of his venture of defaming the person who are there in the picture. So I have unintentionally become the part of his track of defaming someone, and I may be liable or part of that activities which I may not be aware of. An action can be initiated against me under IT law as well as under Indian Penal Code. So overall, IT law, IPR law and Indian Penal Code all are together protecting our Indian intellectual property rights in India. So only obtaining a right is a part of getting incomplete right until we get the protection, until we get the authority to get it used exclusively, and that will come only after getting it registered through proper procedure laid down under law. Once we get it registered, that means it is our right, and that right is legally protected interest, which also coupled with IP law. Okay, from my side, it is over. I am really thankful to Niranjan ji, to NCSM, and to all the person who are really hard, who has given hard work to make this possible, this wonderful program possible. I am grateful to NCM, to DSC Digha, to Niranjan ji, to Ramchandran ji, to all persons who have given me the opportunity to share my views to this whole world who are witnessing this, watching this through this social media. Thank you very much. If anybody had any questions, I'm ready to respond up to my best.
Thank you very much, Dr. Sasinath Mandal, for explaining the IP protection in very nutshell, and especially the cyber IT protection also, and various type of intellectual protection of copyright, patent, trademark, GI, and his lecture will really help to aware the people, especially nowadays. More and more people are using the social media platform and for transferring and sharing the knowledge, but how this sharing is becoming a criminal act, that has been now understood by his lecture. So this is the new things which we know, and this is also so much complicated. Legal things are always complicated, but very thankful to him for explaining in a very simple language for the simple people, simple person who has less knowledge of law, because law is always very complicated things and people doesn't want to enter in this periphery for these complications. So anyway, very much thank you for his views and sharing his knowledge for IP protection, especially the cyber protection nowadays, and explaining the IT Act 2008 as well as 2019 also, and various amendment, even the farmer rights and pharmaceutical rights and innovation rights also. So I think the center and the audience will also get so much of information. And if any type of question regarding this is there, then I can invite him, and they can write the mail also to DSC Digha, as well as in Dr. Sasinath Mandal also, and we can forward your questions to Dr. Mandal sir for explaining the thing. And thank you very much to all of the persons. Now I will invite my colleague Mr. Devashish Dhar to give the vote of thanks for this program to all our dignities. Devashish.
Thank you, sir. Am I audible?
Audible.
Okay, sir. Well, from today's lecture, we must say respect for inventor is the key for success of a patent system. So, good afternoon, everyone. And we have almost reached the end of this beautiful program. It is such an honor for me to get the opportunity to thank you all the dignitaries. On behalf of Digha Science Center, I, Devashish Dhar, Education Officer, extend a warm welcome to everyone in this program. I would like to express my gratitude to all esteemed delegates of the webinar for their presence and contribution to make this webinar on intellectual property rights a great success. I extend my gratitude to our Honorable Chief Guest, Dr. P.K. Misra, Vice Chancellor, Jharkhand University of Technology, Ranchi, to take out some time from his busy schedule to grace the event. Thank you, sir, for inspiring us with your outstanding words and valuable words. Special thanks to our guest of honor, Director BITM Sri V.S. Ramachandran, for his support and guidance for organizing such an event. Thank you, sir, for assisting and encouraging all of us. Special thanks to Honorable Speaker, Dr. Sasinath Mandal. Thank you, sir. And my heartfelt congratulations for Sri Niranjan Gupta, Project Coordinator, Digha Science Center, for inspiring, assisting, and guiding us to organize such an event. I congratulate all the participants for their active participation. So thank you, everyone, once again for making it a great success. Thank you.
Tomorrow we have another session, and the session will be conducted by Mr. Ramya Kumar Kalidaha. Basics of IP and how to file a patent is one of the important part that we should know. So tomorrow, Mr. Amit Patel from Gujarat Technical University, he will explain about how to file the patent and how to search the patent through websites as well as the various tools. So with the permission of our chief guest, special guest and speaker, today we are now closing our program. Thank you very much for all the support. Tomorrow some 4 more lectures will be delivered. Small short talks will be delivered by various professors also. So they requested, and Dr. Sasinath Mandal also given so much of taking trouble for this program conducting. So anyway, his support is always there for our Science Center, and Sri Amio Kalidaha is also supporting always for all our program. And thank you very much again to all, and with the permission of our chief guest, our director, we are just closing today's session. Tomorrow again we will meet at 12 o'clock. Thank you very
My
much.
best wishes to all of you.